Section 21, Office Record Keeping, Arizona Commissioner's Standards, Requirements for Licensees. Introduction, if it's not documented. It didn't happen. Jessica had just closed a deal. Everything went smoothly, happy clients, signed documents, and a successful closing. She moved on to the next transaction without thinking twice. A few months later, her broker asked for the file. Where's the earnest money receipt? Do you have the original contract? Where's the communication confirming instructions? Jessica realized something in that moment that every agent eventually learns. Closing the deal is only half the job. Documenting the deal is what protects you. This section is about one of the most critical and most overlooked areas of real estate compliance, record keeping. The 5-year rule, your compliance timeline. Under ARS Paragraph 32, 2151.01, brokers are required to maintain records of each transaction and employment for at least 5 years from the date the transaction or employment ends. This is not optional. For example, if Jessica closes a transaction today, that file must be retained for 5 years from the closing date. If an agent leaves the brokerage, their employment records must also be kept for 5 years from the date of termination. Another important detail involves rejected offers. These must be kept for at least 1 year. However, if a rejected offer becomes part of an executed contract, it must be retained for the full 5-year period. Jessica realized that record keeping is not just about what happens during the transaction, it's about what happens long after it ends. What records must be kept? Arizona law requires brokers to maintain complete and accurate transaction records. This includes all documents related to the transaction, not just the final contract. Examples of required records include earnest money receipts, which confirm how funds were handled, closing statements showing all financial activity, and complete copies of sales contracts. If applicable, this also includes listing agreements, employment agreements, escrow instructions, and any related documentation. For example, if Jessica handles a transaction and forgets to keep a copy of the closing statement, that file is incomplete. If she cannot prove how earnest money was handled, that creates a compliance issue. The goal is simple. Every transaction must tell a complete story through its documentation. Earnest money and financial tracking. One of the most critical parts of record keeping involves tracking money. Brokers must maintain documentation showing that all funds were handled according to the instructions agreed upon by the parties. For example, if earnest money is deposited into a trust account, there must be a record showing when it was received, where it was deposited, and how it was ultimately dispersed. Another example is a dispute over funds. Without proper documentation, it becomes nearly impossible to prove what happened. Jessica learned that when it comes to money, documentation is everything. Organization matters. Chronological logs and systems records must be maintained in a systematic manner that allows easy access for inspection. This often means using a chronological log or organized transaction folders. For example, each transaction file should include all documents in order: contract, disclosures, amendments, receipts, and closing statements. Another example is using transaction management software to track files digitally. As long as the system is organized and accessible, it can meet compliance requirements. Jessica moved her brokerage toward a digital system with clear file naming and timelines. It made audits easier and reduced errors. Where records can be stored, records must be kept at the broker's main office, a licensed branch office, or an approved off-site storage location within Arizona. If records are stored off-site, the broker must provide written notification to ADRI with the address of that location. For example, if Jessica uses a third-party storage facility or cloud-based system with a physical server location, she must ensure proper notification and compliance. The key requirement is that records must be accessible for inspection by ADRI when requested. Inspection by ADRI. Be ready at any time. All records must be open for inspection by the commissioner or their representatives at reasonable times. This means that if ADRI requests a file, the broker must be able to produce it. For example, if Jessica is audited and cannot locate a transaction file, that becomes a compliance issue, even if the transaction itself was handled correctly. This is why organization and accessibility are just as important as retention. Real-world example: the missing file. A complaint was filed against a brokerage regarding a transaction that occurred 3 years earlier. ADRI requested the file. The broker could not find it. Even though the transaction may have been handled properly, the lack of documentation created a problem. Without records, there was no way to verify what happened. Jessica realized that record keeping is not about convenience, it's about defense. Developers and record keeping. If a developer sells or leases property without using a broker, the developer is responsible for maintaining all required records. This ensures that even transactions outside traditional brokerage structures are properly documented and regulated. Office policies and record keeping go hand in hand. Record keeping is directly tied to office policies. Brokers must establish systems that ensure all records are properly created, stored, and maintained. For example, a brokerage may require agents to submit all documents within 48 to 72 hours, use specific transaction management systems, and follow standardized file organization procedures. If a complaint arises, ADRI will look at both the records and the brokerage's policies. If the actions taken do not match the policies in place, it can create additional liability. Jessica realized that policies are not just guidelines. They are evidence of how a brokerage operates. Real-world example. Commission dispute. Two agents disputed a commission split after a transaction closed. The brokerage reviewed its policies and transaction records to determine what had been agreed upon. Because everything was documented and aligned with office policies, the issue was resolved quickly. Without those records, the dispute could have escalated into a legal battle. Civil disputes versus regulatory issues. It's important to understand that ADRI does not handle purely civil disputes, such as disagreements over commission splits. However, if those disputes involve violations of statutes or rules, ADRI may step in. This is why proper documentation and clear policies are essential. They help resolve disputes internally and prevent escalation. Bringing it all together, records protect everything. Record keeping is not just a requirement, it is one of the most powerful tools a broker and agent have. It protects against complaints, supports compliance with the law, provides evidence in disputes, ensures accountability. Jessica realized that every document she saved was more than just paperwork. It was protection for her license and her business. Because in Arizona real estate, the deal doesn't end at closing, it lives on in the file. Online discussion 1. Why is the 5-year record retention requirement so important in real estate? Answer. Because transactions may be reviewed, audited, or disputed years later, and maintaining records ensures compliance and provides protection for the broker and agents. 2. What is the biggest risk of failing to maintain proper transaction records? Answer. The biggest risk is being unable to prove compliance or defend against complaints, which can lead to disciplinary action. 3. Why must records be organized and easily accessible? Answer. Because ADRA may request records for inspection at any time, and failure to produce them can result in compliance violations.